So we'd be done if everybody saved for retirement with their employer. Mm-hmm. But folks don't save with their employer all the time. And when folks leave employers, folks often take money out of their employer-sponsored plan. They open an IRA, they purchase an annuity. There's concerns that the standards of inside the employer plan versus outside the employer plan, there's different rules. Fiduciary rule proponents would say it's unfair or it's a bad thing that there's different rules. And I think opponents would kind of shrug and say, the law isn't designed to have the same standards apply in both buckets, and different products need different rules.
Welcome to the Tao of Chao podcast, where we will try to find balance and provide a clearer path forward in this uncertain world.
Kevin Walsh is a principal at Groom Law Group in Washington, D.C. Kevin counsels clients primarily on issues related to Title I of ERISA, but also works with clients on the intersection of ERISA and other federal statutes. Today, we'll be discussing the 2023 proposed Department of Labor Fiduciary Rule. And here is Kevin. Hello, Kevin. Good to see you.
Hey, Philip. Thanks for having me on. It's always good to be on your podcast.
I know you've done this. This is old hat to you. So this should be something that you can close your eyes and piece of cake. Just talking about things that what you do every day, really. I mean, I think one of the things that I would love to hear you talk about, which has been, I don't want to use controversial, but it's been very confusing, which is really about the reintroduction by DOL of this fiduciary rule. Every so many years, a new fiduciary rule, a new component to the fiduciary rule is being introduced. And often it just doesn't stick around, it seems like, depending on the administration, depending on the environment. Some parts may stick, some parts don't stick. And it's interesting as we sit here, 2024, election year, who knows what 2025 will bring, regardless of what happened to the current iteration, right?
Philip, I think you're spot on. When you described it as I could do this with my eyes closed, I think fiduciary is the alarm clock that keeps waking everybody up.
Well, I think it's the alarm clock that keeps professionals paid. Let me say it that way.
That is fair. It keeps professionals very busy.
Exactly. So maybe I should just quickly introduce what we want to talk about so that all of us can have a baseline. I think this year is the 50th year of ERISA, which stands for the Employee Retirement Income Security Act of 1974. And within that, legislation and then regulation related to it, it talks really about, among many other things, about fiduciary responsibility for those who are trying to offer investment advice. And how to define it in the law, it says, and I'm just going to read it, and this is now is called the 5-part rule, because there are 5 parts. And you have to meet all 5 parts in order for you to be deemed, I think, or considered an investment advisor for a retirement plan. One is you are rendering advice or make recommendation as to the advisability of investing in or purchasing or selling securities or other properties. Okay, that makes sense. Number 2, does so on a regular basis. Seems like, you just don't do it once, but ongoing. And then does so pursuant to a mutual agreement between such person and the plan. So it's not like I can go and do something, but it's some kind of, they didn't say written, but today is under our, and another set of rules that written agreement is important. Number 4, provide advice that serves as a primary basis for investment decisions with respect to plan assets. So it's not like, well, yeah, kind of nice to have, but it's really apparently it's the real primary material reason to follow through with those decisions. And then number 5 is to provide advice that is individualized based on the particular needs of the plan, meaning that this is not informational, educational, but specifically for the plan. Apparently, those 5 things have been, it seems really straightforward, but has been exploited, shall we say. Well, if I meet 4, but not the 5th one, or I meet 1, but not the other 4, I don't really fall into this thing. And since 74 till now, and please share, it seems like a number of attempts have been made to update it or to define it better. Is that true? Is that where we are now? Is to keep going back to the same thing and trying to update it because the world has changed?
So where we are, and I'm glad you used ERISA first because I think the rule was I wasn't allowed to use acronyms or numbers, and so I'm glad we can use that one. So when the retirement statute was passed in 1974, we lived in a world where people had pension plans. You worked for a company for 50 years or 40 years, and you got a check every month from then until you died. The world's changed. We're now in a defined contribution world where folks are responsible for saving for retirement on their own. And they do that, through a retirement plan their employer offers, where they pick the investments or they leave a plan and make individual decisions. And what we're focused on is, when does that retirement statute kick in? So when do the fiduciary protections, the prohibited transaction rules, all the bells and whistles that apply to the types of advice, the types of recommendations, and the care standards that are applicable kick in? And you were right, Philip, for the last 49 years, the test has been that 5-part test that you described. And, it comes down to, is it appropriate today? And, can the Labor Department go further? Now, there are proponents and there are opponents. And Philip, I think you're right. The opponents say there's loopholes. I think the proponents would say that, it does a very good job at capturing when there's a relationship of trust and confidence. But I think we're going to have a robust discussion about the ins and outs of all of this.
Right. So in the old days, like you said, the pension plan, which is my parents' generation, I guess, where you work so many years, the employer said, no problem. If you work so many years and after a certain number of years, by certain age, you can retire and we'll pay you a percentage of your living wage or during your working wage, a percentage of it for the rest of your life. And if you are married and you choose to provide a lifetime income for him or for her, that will continue at a discounted amount. And so it was pretty straightforward. There wasn't much investment to do for the individual. There is really no advice per se. You just work number of years, you meet a formula, and then when you retire, you get a certain amount of income for the rest of your life. So all the responsibility of investment, of the promise, all the risks per se is held by the employer. And today is not.
Yeah, I mean, that's the big shift. You've keyed in directly on it. If we go back 50 years, the folks who received investment advice and the folks who made the investment decisions, it was the employer and the individuals at the employer who managed the plan. If we now jump forward 50 years, the employers have said, we don't want to be responsible for that. We're not going to guarantee outcomes. We'll give you an opportunity. And what that's left us is it's left us with a world where participants and individuals in IRAs or individuals wherever they're saving they're the ones who are making the investment decisions for themselves. So 50 years ago, it was the Studebakers, and today it's Mr. and Mrs. Baker.
Yeah. So when you think in that term, we're trying to sort of fit the current environment into something that was not envisioned 50 years ago. So the law is still holding the plan sponsor responsible for selecting investments, to monitor the investment, to make sure the price is right, it's not too expensive, it's prudent, all those terms that they talk about. So where is the controversy then? I mean, okay, so if the employer say, oh yeah, I'm going to get this list of investment, they're pretty good, and we've selected it correctly, we continue to look at it and make sure that it's still good and it's not expensive. I mean, we're done, right? So why this controversy? What's going on here that makes this keep being addressed and addressed and addressed? What is the issue?
Well, so we'd be done if everybody saved for retirement with their employer. It'd be pretty close to done if it was, everybody saves with their employer, much like everyone got a pension from their employer. Mm-hmm. But folks don't save with their employer all the time. And when folks leave employers or when folks want to have their money all managed in one place, folks often take money out of their employer-sponsored plan. They open an IRA, they purchase an annuity, they open a brokerage account. They do something that takes the money out of the employer system, and now they're in the individual system. And, at bottom, what's happened is there's concerns that the standards of inside the employer plan versus outside the employer plan, there's different rules. And so, fiduciary rule proponents would say it's unfair or it's a bad thing that there's different rules. And I think opponents would kind of shrug and say, the law isn't designed to have the same standards apply in both buckets, and different products need different rules. But so that's the big change, is that in plan versus out of plan.
So if I understand correctly, also we're talking about advice, which something we should sort of probably dive into it a little bit, what that really means. But individuals who help, so the professionals, right? So you may be an insurance broker or agent, or you may be a wirehouse broker or advisor, or you may be an independent registered investment advisor, whatever form that you carry yourself in whatever sleeve of the industry. If you go and you help an individual who is leaving an employer, taking money out, or when they retire, whatever reason, that act of helping people to take money away from the retirement plan, which is subject to ERISA, to something that is not potentially subject to ERISA, I think that's the part that is being difficult, shall we say. Is that the part that the DOL, the Department of Labor, are trying to focus on? Is that what this is going on here?
I mean, that's the $1 trillion question. Over the past 20 years, trillions of dollars with a T have left 401k plans, have left, the plans that people save and make investment decisions in, and have gone to individual accounts or to purchase annuities. So, you're keyed in right in on it. It's a very significant, and at times the most important financial decision someone makes is, what do I do with my money when I take it out of a plan, and when do I take it out of a plan?
Yeah. So let's apply just for a second that 5-part test. Is the DOL saying this 5-part test, when it is applied to those individuals helping retiring workers or exiting workers, that person also has to fill the fiduciary responsibility in the same way as a 5-part test? If you don't meet all 5-part tests, then you're not a fiduciary. But if you meet all 5-part tests, then you're a fiduciary. Is that basically what they are saying?
They want to revise that 5-part test. They want to change the 5-part test so that those recommendations to take money out of a plan become subject to the same rules as recommendations to, a plan trustee or someone inside of a plan. The real challenge here, and the whole ball of cheese, the whole ball of wax, however you look at it, is that, in order to be an investment advice fiduciary, courts have said there has to be a relationship of trust and confidence.
Yes.
There has to be one. It can't be you might have one in the future. It can't be that, you're headed towards one. Essentially a first date doesn't make a relationship. And when we think about that and we look at the 5-part test, the 5-part test has this element, which is a regular basis. When we look at how a rollout recommendation goes, typically the first thing that I'm telling you to do is, I think you should take money out of the plan and then you should give it to me to manage. Or I think you should take money out of the plan and then you should purchase this product. When you say you should take this money out of the plan, you don't have a regular basis yet. It's kind of the first contact.
Yeah.
And that's an issue that DOL has struggled with because courts so far have rejected their efforts to say, regular basis begins at the time you meet.
So what you're saying is the DOL is trying to, quote unquote, protect participants exiting the plan from bad actors. I know you didn't use that word, but I mean the idea.
I didn't use those words. I think if what DOL would say they're trying to do is they're trying to do that. I think if we talk to folks over at the Labor Department, I think that they think that what they're doing is designed to stop that. And I think to some extent that if they impose a fiduciary standard on everybody, it might stop some bad actors. On the other hand, there's some risk of throwing the baby out with the bathwater.
Right. So when we talk about bad actors, is what it means, it seems to me what you're inferring, and let me make sure that I'm correct, is that somebody who has a lot of is in conflict. In other words, I'm really watching for my wallet, make sure I make the money. I am not placing you, the employee who's leaving the plan, interests ahead of mine. In other words, I just basically want to make money off your money. Is that what bad actor means in this case? Basically saying, look, you're not doing the best you can for the client, you're selling them something like auto. I don't mean auto like a bad thing, but a salesperson. Nothing wrong with salesperson, but salesperson, obviously we know which side the bread is buttered, and that is up to the buyer of whatever the product is to be well informed and to make sure that he or she is aware of the situation and able to make educated, informed decisions so that they don't get taken advantage of. Is that the whole idea?
Well, and I think that's the idea, but I think it's a bit of a hornet's nest, and it's kind of a false choice that we're setting up. The Labor Department is saying if we require folks to act solely in the interest of the folks rolling out, we will, eliminate a lot of bad actors. It'll prohibit a lot of bad actions. But, the standard today isn't that, you're allowed to act only in the interest of the salesperson. And this is kind of one of the things that the other side points to. If you're rolling out and you're working with an investment advisor, the investment advisor is held to the Advisors Act fiduciary standard.
Right.
If you roll out and you're getting a rollover recommendation from a broker, regulation best interest and says that a broker has to act in your best interest when they recommend you roll out of a retirement plan. And if you work with an insurance agent, the NAIC guidelines keep being updated. Just this past week, California signed on to, the new best interest standards that are going to be there for insurance recommendations. And so imposing a fiduciary standard is one way to say, you're not allowed to act in your own interest. You've got to mitigate conflicts. You've got to eliminate conflicts. But the Labor Department's not acting in a greenfield. And I guess my comment would just be that, today we already have a whole bunch of regulators who are saying, you've got to put the customer first.
So I think maybe, Kevin, I know the answer to this, but I'd love to hear your thoughts. There's the sole interest standard and there's the best interest. And sometimes people get confused. And if you can just as easy as we can understand, even if you have sole interest, I still get, let's say I'm the advisor. I offer my service and I'm serving solely in interest, but it's not solely because I get paid. So there needs to be some kind of exemption for people like me who are still getting paid. So can you talk a little bit about the framework of how they really work around this sole vis-a-vis best?
Well, so if we think about sole interest, we think about an advisor who's capable of acting solely in the interest. When an advisor goes to a customer and says, hire me to manage your money, It's going to be an AUM, an assets under management fee, an assets under advisement fee, or it's going to be a fixed dollar amount.
Yep.
The advisor, when they're selling their services, they could be held to a best interest standard. They could say, I've got to put the customer's interest ahead when I'm selling my services.
Yep.
But an advisor can't be acting solely in their interest, in the customer's interest when they're selling the service. So when I say, Philip, I want you to hire me to manage your money, I'll charge you a flat fee. In that moment, I can be acting in your best interest, but I'm not acting solely in your interest because I have an interest in getting paid.
Exactly.
With an advisor, once I've been hired, I'm getting that fee. The recommendations that I make, my comp doesn't go up or down based on saying, pick A versus B,
right?
Invest in this product versus that product. So at that point, I'm able to act solely in your interest because when I'm comparing options, neither option benefits me. And so I can act solely in your interest. When I look at, brokers or, insurance agents, where there's no upfront conversation saying, hire me. Even if you don't take my advice, you're going to have to pay me a fee.
Yep.
But it's only if you buy something. Do I get paid a fee? In that situation, a sole interest standard doesn't really work because, if I'm saying, Philip, buy this water bottle, but I only get paid if you buy this water bottle and I don't get paid if you buy that water bottle, it doesn't work. Yeah. So, every financial professional has some conflict.
Sure.
In terms of they've got to get a relationship where they get paid, but different models present conflicts at different points.
So under ERISA framework, I still get paid, but I can still work in the sole interest. It's because there's an exemption, exemptive relief, or whatever they call it, right? So that ERISA says you can do that because I understand that nobody does it for free. So you have to do these things. If you do these things, then we'll forgive you. You're still watching out for the sole interest. Is that how it works?
So, it's kind of two parts. One is that they have these prohibited transaction rules. And the second is they've got the sole language in 40. So they've got the sole language, and I'm not going to use sites.
Yeah.
But the big thing essentially is that the way that folks have interpreted ERISA over time has been that, if you comply with an exemption, and basically the Labor Department and Congress have created these, if you do X, Y, or Z, you'll be deemed to have satisfied these rules, even if what you were doing is technically prohibited.
Yeah.
Essentially, folks are deemed to have satisfied that standard, even if there's a conflict. So I think what you're getting at is, if we look at aspects of insurance distribution, or aspects of brokerage, or aspects of the commissions with mutual funds, the Labor Department has said, if you do X, Y, and Z, then you'll be deemed to have satisfied our solely standard, or we'll give you a pass essentially on the solely standard, even though solely and best interest mean different things.
So, Kevin, let's maybe turn attention to some practical aspects. So one is a lot of record keepers. Well, let me set up my my thoughts first.
All right, Philip, you're getting me in trouble here. I see what we're doing.
No, I don't want to get you in trouble. So what happens is, it has been a free compressed world for a very long time, 20 years. And we have not, as an industry, really appreciate the amount of work and amount of investment a record keeper has to do in order to service an ever-increasing demand of participants and plan sponsor, as well as new regulations and new regulation. So fees are coming down, work has to increase, and a business cannot sustain itself. So they start building other services to sustain themselves reasonably enough. As far as I can tell from court cases and after court cases, that third-party administrator record keepers have never been deemed to be a fiduciary. Not yet, at least. What they do is very clearly, they say, we're not fiduciaries, we're just doing our work and record keeping, ministerial work, and so on. Now, there are increasing number of record keepers are now owned by either insurance companies or by asset managers who happen to have IRA accounts. And so when one of the employee leaves, they may be approached by their record keeper and say, hey, if you're leaving, if you want to, let's say they don't even tell you to do it. If you want to, we have IRAs that you can roll in, and we'll keep the investment because, let's say, the investment is already with them. Under the fiduciary rule, proposed fiduciary rule, would that make them a fiduciary?
So, that's a great question. And some of it comes down to how that conversation goes. If it's just simply something like, if you want to stick with us, we've got a button that you can click to stick with us. We're not telling you to stick with us, but here's a button that leads to our IRA. In all likelihood, that wouldn't trigger fiduciary status under the new rule. Now, if they're doing something more than that, they're saying, you've been in the plan, you're leaving your employer, don't leave your money with your old employer, roll it over to us. In all likelihood, under the new proposal, that would trigger fiduciary status. So, there's this concept of investment education, which is important today. And it's going to be important going forward. And some of it comes down to how specific the communication is. If it's a call to action, I think is the terminology we like to use. If it's a call to action and come to us, then in all likelihood in the DOL's proposal, it would trigger fiduciary status. If it's something less than that, but just making you aware of your options, that's unlikely to be fiduciary today or tomorrow.
Because if I look at the 5-part test we talked about, it seems like they could meet all 4, but not the 5th one, which is ongoing, right? They can just say, hey, I just gave you advice one time, or we don't even want to call it advice. Certainly it's personal, certainly it's specific, certain decision is based on that, but it's not ongoing. It's just like, hey, make a decision, good, we're done.
Well, and so that's today. That's under today's. But under the proposed test, the regular basis prong is being reinterpreted.
Yes.
And so, if we look at it today, it's, am I giving you, Philip, advice on a regular basis.
Yes.
The way that DOL is trying to propose it now is, am I giving advice to the marketplace on a regular basis? So I give Philip advice once, I give Tony advice once, I give Jane advice once, and suddenly I have a regular basis of giving advice. So in the record keeper scenario, under today's rules, the record keeper says, look, I'm only giving Philip advice once, worst case scenario, so I'm not a fiduciary. Under DOL's new proposal, they're going to have to take a much closer look at their actions, really develop more compliance strategies, because, for every Philip, there's probably, hundreds of other individuals who are getting, one-time advice, which in the aggregate becomes
ongoing. Yeah. So I'm sure they're pushing back. Now, when they talk about changing various interpretation, or you think they're actually changing the verbiage period, or they're just changing the way by which the exact same 5 parts now all of a sudden is interpreted differently?
Oh, they're changing the verbiage. They're changing the words.
They're going to change the whole shebang, so to speak.
The whole shebang.
So the biggest pushback when I listen has been from the insurance industry. Insurance industry tend to be, I'm talking about life insurance industry, especially for using annuities, they tend to be purely, thus far, been purely commission-based. And the commission is not a small amount. And I know why commissions are high, because it takes a lot of effort and things to do in order to sell an annuity. So the reward seems to be significant, or at least from a layperson standpoint. And they are pushing back significantly. They said, well, we have our own regulations. And like you said, California just came out with best interest. Is their best interest, you think, will go across the country sooner or later, eventually? And 1, 2, is their best interest the same best interest that the SEC talks about, or are they different?
They're different best interest standards. The SEC best interest standard is under regulation best interest. And, there's about 200 pages of rules that interpret what best interest means. They both require mitigation of significant conflicts. They both require elimination of certain types of conflicts. And at bottom, they both require that the broker or insurance agent put the individual first.
Yeah.
But they're not identical standards. And that's been one of the key focal points by the Labor Department, is that, even if folks don't like ERISA's solely standard and say that solely is unworkable, the Labor Department seems frustrated that best interest can mean different things. But I think you're making a key point there, Philip. Now, when we look at insurance and we look at commissions, I think it's important to keep in mind that, the products are more complicated, and more complicated is a good and bad thing. It may be a product that's better able to meet someone's needs. It may be just a more complicated product in a bad way. But in terms of actually buying an annuity, there's typically a lot more paperwork. It typically requires significantly more handholding than purchasing a mutual fund. And that's part of how the industry justifies the commission structure. But, it's one area where there's been evolution in terms of not just the commission structure, but evolution in terms of oversight and care standard. And, this is one of those areas where, it's kind of frustrating that Congress, in its infinite wisdom, has different regulatory structures for different groups. But traditionally, the states regulate insurance, the SEC regulates advisors and brokers, and the Labor Department regulates inside of 401k plans and pension plans.
Yeah.
And you know what? It seems odd that we have all these regulators at the playground, and DOL wants to regulate more than just its sandbox. It wants to regulate the monkey bars as well. And there's going to be some give and take here.
So I think at the end of the day, if every regulator's mission is to protect and to serve the public, right? I mean, I assume that's a fair sort of overarching statement. By having all these different regulators, all these different potential variation of doing the best for the customer, whatever that means, it's confusing to a customer, a person. If I'm going to retire, I say, oh, there's this best standard, there's that best standard, there's this and there's that and that. I am totally confused. I end up saying, why do I need all this stuff? I mean, I'm just going to talk to my next door neighbor who has been my next door neighbor for 30 years. And he came over and I told him I'm going to retire. And he said, well, look, let me help you. Let me just help you. And I will say, look, I don't care about all this stuff. I trust him. I like him. He's helped mow my lawn every now and then. Great. Let me give him my money and he will take care of me. He knows my wife. He knows my kids. It could be my brother-in-law. I'm just using next door neighbor for example. So the problem is individuals who are not super aware of the conflicts may end up making a selection that may not necessarily be the best for them, may not necessarily be. I don't want to knock every neighbor because there are plenty of good neighbors. I'm not saying they're not. We have this tug of war all the time. And so you are right. I think at one time or another, you said, look, we cannot squeeze out all the bad actors. I mean, there are bad actors, there are bad actors. But the question is, how much squeezing can we do and still leave some bad actors? That's fine. That's why there's liability involved. I mean, otherwise we don't need a rule. If we know there's no bad actors, we are done. Mm-hmm. Let the law take over. But what is that boundary? Isn't that what they're talking about?
Well, yeah, you're keyed on a great point, and it's the balance of access to recommendations, access to financial products, and then paperwork and compliance. We look at regulation best interest that the SEC did, and one of the reasons it came about was folks were confused about whether they were working with an investment advisor, a fee-based individual who you pay a fixed amount and then they don't get a variable amount based on commissions, or if you're working with a broker who's another type of financial professional who makes recommendations, but they only get paid when you buy something. And so the SEC came up with new rules, new standards. They also created a new 4-page disclosure, which is designed to educate folks. It's more plain English. It's a whole lot more plain English than the prior disclosures.
That's nice.
But a real challenge here is that, the solution, if it's more paperwork, if it's more disclosures, it can help mitigate the confusion only for people who read them.
Yes.
And we see the same thing. It's like we say, folks don't realize when they're working with an insurance agent what the insurance agent's getting paid or what the conflicts are. And, under today's rules, you've got to provide a disclosure that says, here are the conflicts and here's what I'm getting paid. So it is kind of a balancing act of, do we need to pile on higher? And if we're piling on higher, would it make sense to revisit some of the things we're already doing? Because we already have a ton of paperwork, a ton of disclosure, and a ton of regulatory structures, and we're complaining about the same thing. We've made robust changes in advisor registration, in broker regulation, in insurance agent regulation in the past 6 years, and it's not clear to me that retail customers or anyone has figured out if those changes are going to be enough.
Yes.
So my worry with fiduciary is that to some extent, we're saying, this fence doesn't do a good job, but we haven't seen if the fence works yet.
So I always torn about disclosures. It's what you all do, right? It's legalese in saying, telling you, if you really believe in disclosure, you will never do anything that's been disclosed. I mean, it's like mutual fund prospectus. I mean, it's a form of disclosure. You should read your mutual fund prospectus before you make an investment decision. I dare say that less than 1/10 of 1,000th of 1% a person even flips through the first 5 pages of a prospectus. I mean, they just don't. And if you flip through the prospectus, it tells you all the risks. I mean, by the time when you're done reading that thing, you say, why would I ever want to be in this investment, for example? So it's the same thing. Disclosure doesn't work. If it worked, nobody would be a smoker. Never would have smoked. You would die of lung disease. Oh, well, I don't want to do that. So disclosure is totally meaningless, even if you read it.
I hope I disagree with you here. If disclosure doesn't work, then we're basically saying folks can't make decisions for themselves because they make bad decisions.
So my point.
Go on.
My point is not that it doesn't work; it's that it's not enough.
Okay.
In other words, it's not 100% working. It's some percent, much less than 100. And sometimes I want to do something. I want to hire my neighbor. It doesn't matter what the disclosure says. You know what I'm saying? Disclosure only works if we are an insider and understanding what that disclosure really means and how it really hurts or not hurt me. And I'm not sure everybody can read that and understand the complexity of that disclosure. It's not just black and white words. That's what I'm saying. So I'm with you. So let me ask you a sort of final question on this thing is, this is another approach. In the last, I don't know, three administrations, we have had 4, I think, attempts in rewriting or some portion of this, and keep flopping back and forth. And we are actually right now potentially back, not potentially, we are right now back to the 5-part test right now.
Mm-hmm.
Right. I mean, after all that, after 50 years of this, we're at the 5-part test. Help us take a look at what DOL is doing now. We sort of talked about why they're doing it, maybe well-intentioned, maybe extending their reach, whatever. What do you think that one should do about this 5-part test? Or you think we should just leave it alone, and why?
At this point, I would suggest that the Labor Department leave it alone. And the why is because we've got a bunch of regulators, Congress, the states, the SEC, that are all trying to regulate the same space. I would suggest, give some time to see if those rules work, and recognize that the Labor Department's not a panacea. It's in an awkward spot trying to regulate more broadly, trying to regulate insurance, trying to regulate brokers, trying to regulate investment advisors outside of the plan context. It's lost in court a handful of times, and I'm suspicious that, if I had to be a betting man, I'd bet it loses again. If we're unhappy with the care standards that folks owe, Congress should take a look at it and figure out if it makes sense the way they've structured it. I think there are good arguments both ways. There's good arguments that insurance is regulated well by the states. There's good arguments that, the SEC does a good job at regulating investment advice. There's good arguments that the Labor Department really puts the interest of participants first in the areas that it has control. And the arbiter of, how those balances are going to be made, whether it should be a single regulation or not, I think we've really got to look to Congress for that. And I know that Congress is slow and Congress is relatively, at times, dysfunctional. But if we're going to be dramatically changing the way that folks save for retirement, it should be something that has a broad consensus. And a problem that we've had for the last couple of efforts has been there hasn't been broad consensus. Courts have struck it down. And while we can all envision a better world, the issue we face is that everybody's better world looks a little bit different. And then we find ourselves at odds. And the 5-part test, for now might be as good as it gets. And that when folks find folks who they want to work with for retirement saving, for financial planning, if someone holds themselves as an insurance agent, a broker, or an advisor, it's going to be important for individuals to ask good questions, to understand if they're picking somebody who is going to work for them. Because we do have a robust regulatory structure today, but it's no substitute for understanding the individual who's giving you the advice and what their incentives are.
While you were explaining, I was also thinking one other thing is really, there is this movement towards more managed account, and you know that very well, where your money is managed with more personalized. What most folks don't understand is that managed account also comes with advice. In other words, there will be a somebody at that organization who can help you and have interaction with you. So that's one sort of one extreme. The other are really financial wellness, which is a kind of, I don't know how well defined it is. To me, it's very squishy. It can mean so many different things, and it also have a education component, right? Now, there are two things that I like to sort of ask you. One is education really has not worked. Advice has, but education hasn't. Okay, I'm sorry. So one, that's me talking.
How do we make it work? We've got to make it work. At bottom, folks have got to get to retirement, and none of this works if folks make bad decisions.
Okay, because behavioral finance tells us people make bad decisions. So I think the education part has not worked. That doesn't mean it will never work. Thus far, has not worked.
Fair,
but there are some specific rules about education and advice, and I think DOL had talked about it, I don't know, half a dozen years ago. And today, again, a lot more people are moving ever so closely to advice, but no, it's not advice because we're living just on the edge of education. But actually, it's getting close to advice. And as we get closer to advice, and as we get closer to making, I think it's the fifth point, provide advice that is individualized, right, based on the particular needs of in this case, participant. We are crossing over one part or two parts of the fiduciary rule without being a fiduciary. So we are very clever people, right? For every lawyer who writes this, there's another lawyer who can, work around it. And then there will be another lawyer who can do. So where does this end? It is the state of this pathetic state where we are, or is there anything else that you think we can do or we should do? Forget the 5-part test. I'm just sort of thinking more broadly. Any thoughts on that, Kevin?
Well, so Philip, I think you've keyed on a big thing, which is kind of the line between education and advice. But we haven't kind of teed on the pro or the con of why folks stay on one side or the other. If you take on fiduciary responsibility, you do open yourself up to a lot more liability. And so, if we want folks to get educated, we want folks to, make better decisions. The preference is usually going to be to educate folks without taking on fiduciary status. The goal will be get as close to that fiduciary line as you can so that folks understand as best they can the decisions they're making, what their options are, but don't take on liability yourself. Now, the investment advice side of the line, you're taking on that responsibility. You're traditionally getting paid for it either as an advisor or as a broker or as an insurance agent, but you're taking on some liability. Where do we go from here? I think it's going to be really important. I think we should be encouraging plan sponsors to work with, record keepers and others on getting some level of financial literacy program for employees. Without financial literacy, I don't know what we're doing, because no matter what we do, folks will make bad decisions. You've said it, Philip, and you look at the behavioral economics, you look at nudge, you look at all those things, and folks don't make great decisions.
That's right.
The most important decision someone makes is to save more money. And honestly, if you're an advisor, a broker, or an insurance agent, you're conflicted when you tell someone to save more money. An insurance, an RIA or an advisor, if they're getting a fee based on the assets under management, they have an incentive to say, hey, save more money. On the other hand, it's a good conflict because it's the advice that people need to hear. So, as we look at this, it's not that every conflict's bad. It's that we've got bad actors and we need to put a framework in place where individuals can determine that the person they're working with is someone that's, reputable, someone good to work with, and is going to give them recommendations that help them get best to a good outcome.
So let me conclude by saying, if I understand this whole conversation, that we are at a place where we are about as good as we get at the moment, and much higher power needs to come to intervene this, such as Congress, so that a more uniform or unified set of rules can be used. But not until then, we will continue to have various kingdoms fighting for the empire. Is that a fair statement?
Yeah, I think if we want uniform, we're going to need Congress to act. And in today's world, I think we make a mistake when we focus only on the DOL fiduciary standard and we don't look at the NAIC standard or the SEC standards because, as an ERISA lawyer, I get myopic myself. I look at it and I'm like, oh my gosh, if labor's not regulating it, it must be the Wild West. And I sleep better at night when I then look at the rules that other regulators have out and I realize it's not the Wild West out there. It's somebody else's jurisdiction.
Right. So at the end, it's about turf war.
Turf war, yeah. It's all a turf war.
Human nature, that's where we are. We haven't moved too far from the Stone Age.
It's a Game of Thrones.
It's a Game of Thrones. Oh my goodness. Kevin, thank you so much. I think this is a great conversation for me. I learned about the more pragmatic and more educated, more informed view from you than I'm trying to figure it out by reading all the different articles. So thank you very much, and hope the audience also found that to be enlightening. So I appreciate you joining me and spending time with me today.
Well, Philip, thanks for having me on. It's a really important topic, and anytime you want to talk about it, I'm happy to come on.
Thank you, Kevin. Appreciate it.
You can always find more episodes by visiting philipchao.us/podcast or find us on your favorite podcast app. You can always leave us feedback, ask questions, or request a topic for us to discuss by sending an email to pc@philipchao.us.
Views expressed in the Tao of Chao podcast are individual opinions, and they do not represent the employers of each guest or the firm each guest is associated. Our podcasts are for educational and informational purposes only and should not be deemed or viewed as investment advice or recommendations. Please consult your personal financial advisor, investment expert, or investment fiduciary before taking any actions about your plan and investments.